Welcome to Tri-County's legal panel. First of all, let me introduce myself. I'm your 2021 Tri-County's president. And before I introduce our monitor, I wanted to tell you about our upcoming membership meeting. On Friday, April 9th, from 11 a.m. to 1:30 p.m., Tri-County's is having a general membership meeting. Our keynote speaker is Lee Brown. Lee is a realtor and motivational speaker, and her presentation is entitled A New Real Estate Year, Fresh, Focused, Forward. We also have an economic forecast from Oscar Wee from CAR, followed by John Giardinelli, who will provide a legal update, and then Tim Shaw and Christine Schachter will provide us a legislative update. To register, go to Tri-County's website at tricorealtors.com. I would now like to introduce our moderator, Ed Estes. Ed is a real estate broker and an attorney with over 40 years experience in real estate brokerage and legal matters. He is a full-time tenured professor and the real estate coordinator at Mount San Antonio College, and will be acting as moderator for this forum. Ed, we're excited to have you, and I know that our panel has some great information to share, and I anticipate our audience will have a lot of questions. So let me turn it over to you now, and let's get started.
Okay, well, thank you much, Brian. I do appreciate the opportunity to be here and moderate this great panel. Let me introduce our panelists today, and they will be fielding your questions. The first is Carlo Benky. He has been with the Department of Real Estate for 16 years. He is the Los Angeles District Office Special Investigator and Facilitator. Carlo has reviewed over 2,500 complaints against real estate licensees and unlicensed real estate activity for violations of the real estate law and the commissioner's regulations. James Demas has a bachelor's degree in history from UCLA and obtained his Juris Doctor degree from UC Davis School of Law. He is a member of the California State Bar and has been since 2003. He joined the Department of Real Estate as a staff counsel in 2006 and became the Assistant Chief Counsel for the Los Angeles office in November 2013. Jeff Samata is the Director of Compliance and Data Licensing, Assistant General Counsel in CRMLS, and has been a real estate and business litigator since 2014, representing realtors, homeowner associations, as well as the Corona City Attorney's Office. A past real estate sales and loan agent, Jeff teaches real estate law at California Baptist University in Riverside. And of course, finally, and but not leastly, someone you're all familiar with, John Giardinelli. He's an attorney who specializes in real estate and business law with an emphasis on broker representation and broker defense. He also represents 9 realtor associations, including ours, the Tri-County Association of Realtors, with a cumulative membership of over 40,000 throughout Southern California. Now, a little bit on the rules of the forum. We would like you to submit your written questions. We are keeping the mics muted because, as Laura has shared, we have almost 200 people. And if we tried to open up the mics, I mean, we would just be talking all over each other. So if you can use the chat, go ahead and type your question in, and I will be monitoring the chat. I will be interpreting and answering your questions. If you would like to direct a question to a specific panelist to start, you may do that as you write your chat question. But all of our panelists are welcome to join in. Typically, what I urge is 1 or maybe 2 other panelists join in on that question. But after 2 or 3 people have had their chance at a question, we've pretty much covered everything. And I then tend to go on to the next question. So also want to specify our disclaimer that if you are looking for legal advice, this is not the venue for that. This is an educational experience. However, if you do need a referral to an attorney, I'm sure one of our panelists can help you in that regard. But again, I do want to specify that this is a legal forum for educational purposes, not a substitute to talk to your own legal counsel. Now, as you are writing some of your questions, I would like to give our panelists an opportunity to maybe opine on some issues that they consider to be important or that they're seeing out there in the field. Some of you may be able to relate to this as you are drafting your questions. Why don't we start off with Carlo, give us a little bit of a DRE's perspective of what he's seeing out there and some of his concerns. Carlo?
Thank you, Ed. Good morning, everyone. As Ed said, I've been with the department for 16 years, and I'd like to start off with the department's mission statement, which is to safeguard and promote the public interest in real estate matters through licensing, regulation, education, and enforcement. I'm with the enforcement section with the department, have a 9-item list that I could go over, but I'd like to start off with the complaint process, how typically a complaint works when we get one at the Department of Real Estate. I'd like to also say that most of my comments will be my opinion and not the opinion of the Department of Real Estate. So typically here at DRE, there's a chain of command that creates a redundancy to protect the integrity of the complaint. For example, there are instances where we'll have a overzealous complainant who's out for blood. And we at DRE, where we're trained is we go where the evidence takes us, not necessarily because someone's alleging or screaming foul. And just as a background, there's 3 standards of proof typically in legal jurisprudence. The highest standard of proof is in criminal law, which is beyond reasonable doubt. The second standard is what we do at the Department of Real Estate, which is administrative hearings, is clear and convincing evidence. And the lowest standard is civil law, which is preponderance of evidence. So the licensing community out there, which approximately, I believe there's about 445,000 licensees in the state of California. I want to sort of let you guys know that we at DRE, we get it, that this is your livelihood, that this is what drives the economy in California. And so anytime we get a complaint, there's a process that we vet out complaints. There's a complaint intake unit that determines that this case lacks merit or there's merit to it, and they'll set up a case. And so when an investigator gets the case, for example, if I get a case, I have a supervisor that I report to on a daily basis. And so we try to get the other side of the story, not just the complainants. So much as I want to say the bedrock principle of the department is consumer protection, but as I mentioned in the mission statement, we work with the licensing community. So anytime there's a complaint and you get a call from the department or an investigator, don't be alarmed. It's nature of the beast. You're a licensee, you're going to work, and you're going to have instances where a competitor is not going to like you, or a seller or a buyer may have had a falling out, and their knee-jerk reaction is to file a complaint. Well, we at DRE, we're going to go through methodically the process, and if there's merit to it, well, there's a hearing, and thank God for that, because you get to explain your side of the story. I also want to add that most of our investigations are confidential. The ones that go to hearings are public record. So once it goes to a hearing, it becomes public record. But if there's a complaint that lacks merit, we're not Yelp. We're not some sort of a chat, online chat room or something where we get to spill the beans on some licensee. Everything's confidential. We take pride in what we do. And if I could put everyone's mind at ease that nothing at DRE is done without proper protocol. I like to, if Ed, you're okay with this, discuss broker escrow and referral schemes.
Sounds good.
So years ago, let me actually go back to one more thing about the Department of Real Estate. In 1917, California became the first state that actually created a regulatory body that oversaw real estate. So I take pride in being part of a organization that goes back over 100 years. And with that comes a lot of depth and knowledge that trickles down through our commissioners, through our assistant commissioners, all the way to our first line employees. So anything that we've done goes through the legislature, signed by the governor, and it's thought through. To mention broker escrow, you have to understand that there's a distinction to be made. Most escrows in Southern California will be handled by, and I like to say this because this is three prior names. Initially was the Department of Corporations and Bank. They had a name change, and they recently had a name change, the Department of Financial Institutions and Innovation. Most escrows in California or in Southern California are done by Department of Financial Institutions and Innovations. Most escrows in Northern California are done by title companies. Title companies are regulated by the Department of Insurance. Statewide, the Department of Real Estate has given an exemption to real estate brokers to conduct their own escrows. And it's a bit nuanced because if I'm a broker and if I were to broker my own escrow, I would have to have one of my own agents involved in the transaction. So either I have an agent that's the listing agent or I have a selling agent that representing the buyer. I cannot, as a broker, do an escrow for agents that are not part of my brokerage. That would be a violation, and it's called third-party escrow. When you're conducting broker escrow in California, you want to, there's a threshold reporting where if you're doing 5 or more broker escrows in a year, you have to report that to the Department of Real Estate. If you're doing over $1 million escrow, you have to report that to the Department of Real Estate. If you're doing broker escrow, there's an added responsibility. You have to have a trust account, and you can't commingle your trust account with these escrows, seller's proceeds, with your business account. And so that subjects the broker to random audits, which is good. It protects the consumer, and it keeps the broker to make sure they're doing their monthly reconciliations. So I worry about broker escrow because they're, unlike the Department of Insurance and the Department of Financial Institutions and Innovations, we don't require a fidelity bond. And the fidelity bond is something that I think it's very important that you need. So you, as the licensed population out there, if you come across a broker escrow, it's incumbent upon you to protect your consumer to go on our website, make sure that broker does not have a restricted, does not have a expired license, has the broker designation for non-independent escrow. You want to sort of do your homework so you don't have a situation where the broker takes the seller's proceeds and runs off with the money. So it's not that bad. In 16 years, I've had a handful of broker escrow cases, which, just to give you perspective, in 2007, the Department of Real Estate's broker escrows did $7 billion, that's B with a billion, in escrow transactions. That's a lot of money. So if you have a handful of bad actors doing broker escrow, that's millions that could be lost. So be on the lookout for broker escrows, be vigilant, do your homework. And if there's any questions, but I take pride in saying this, my number's on the department's website under the complaint resolution program. I'll give my number out today. Any questions real estate related, don't hesitate to call me. I'd be more than happy to help.
That might do it. Jeff, why don't we pick up with you? And yeah, and James will answer questions by chat as they come in. Jeff, how about some introductory remarks from yourself?
Hey, no problem. Good morning, everybody. Thanks for having me. Always love speaking to this group and sitting with you guys on the panel. So as Ed mentioned, I'm with CRMLS. We are your MLS. We're not your association. We are two separate organizations. Sometimes people blend those together. But we at CRMLS, we service 40 different associations in the state of California. So we have a very large footprint. And we've got a lot of associations to talk to, and we always appreciate the fact that you guys run this particular panel to keep your members well educated. So from my perspective, I did want to give you kind of a quick, well, maybe not so quick overview on the litigation landscape out there. Some of you may have heard about all the lawsuits that have been flying around all over the place. So I wanted to give you kind of an update on those. The largest and most notable recent development in the litigation landscape was the lawsuit that the Department of Justice, the federal government, filed against NAR, the National Association of Realtors. The DOJ generally takes up matters that they deem important to consumer welfare. And in this case, they did sue NAR regarding some transparency and some consumer education issues. At the same time the lawsuit was filed, they filed a settlement. So NAR and the DOJ had been working on these issues together, and they filed a settlement agreement that is currently in process. I want to go over some of the highlights with it, but just so you know, the things I'm going to talk about are not yet finalized. The settlement agreement and the order from the court basically said that NAR has some time to come up with some rules. They need to promulgate some rules regarding the issues in the settlement. And then they need to go back to the DOJ with those rules and come to an agreement on the language. So that process is ongoing. We thought it might have happened a little bit quicker, but it's sort of stalled out. And the reality is the administration change in January when we elected a new president also involved some changes at the DOJ. So what happened was a lot of the people who are heading up this particular case have either moved on voluntarily or perhaps involuntarily. And so we're not quite sure who has taken up the reins on this particular case. And so the timing on when these things will be finalized at this point is undetermined. So as I talk about these things, just recognize that these are not necessarily issues that are presently, going to affect you. Although here at CRMLS, we have addressed some of them already. So there were 4 topics in this settlement that affect the MLSs and you by extension. The first one involved commission transparency. So the DOJ was concerned with consumers having a good understanding of how their agents are getting paid, most specifically the buyer's agents. And traditionally speaking, in the MLS, buyer's agent's compensation, the amount that the listing broker is going to offer to the buyer side, has been a confidential field in that it is visible certainly within the MLS for the other brokers and agents to see, but that wasn't accessible and viewable by the public. Well, what the DOJ has says, well, we really think that the buyers should know what their agents are making, okay? And to effectuate that, the agreement is that buyer's agent compensation is no longer going to be a confidential field. What does that mean in practice? Well, what it means is here at the MLS, we're now in a situation where we are putting the buyer's agent's compensation in the data feeds that we send out. So if you have an IDX Fed website, or if your broker has a website, you get information from us. You get all the listings so that you can display them. And again, in the past, buyer's agent compensation wasn't included in the payload. Well, it is now. Okay, we have already here at CRMLS changed our payload, our data feed, so that buyer's agent's compensation is available. It doesn't mean that you as a broker or an agent with a website, public-facing website, have to display the BAC. It just meant that we had to allow you to do so if you want to. So as of now, even though this rule has not necessarily been finalized, we're certain that it will be in this particular format. We have included buyer's agent's compensation. So if you would like to show that on your websites, you can do that. From our perspective, we do have a public facing page as well called HomeSnap, and now BAC is being displayed on HomeSnap as well. And this is not necessarily a new development. This has been going on with some large brokerages and some other MLSs throughout the country for a while now. Northwest MLS has been showing BAC for a couple of years. Redfin has been showing BAC on their own listings. So it's really sort of a move to this idea of greater transparency. And this is one of the main points that the DOJ wanted to address. The second issue was sort of involved the DOJ's concern about steering. And what I mean by steering in this case, in this context, is that they were concerned that perhaps buyer's agents were steering their clients only towards listings with a certain sort of minimum compensation. You know, if there's a list of listings that come up in a search result for the particular buyer, and 10 have 3% and 2 have 0.5, the DOJ was saying, well, we really would rather that we take away the idea or the temptation for buyer's agents to move their buyers in the directions of the higher comp listings. Now, that said, we did some research on this at CRMLS, because we can go into our system and figure out every search that's ever been conducted by our users. And these searching listings by compensation or filtering them by compensation, frankly, are virtually non-existent. Okay, so was it a real thing? Well, our data indicates that it wasn't. Nonetheless, what we've done to comply with this is what the DOJ is saying basically to the MLSs is don't let them do this anymore. So what we had to do is go into our platforms and disable the idea, the capacity for you to search by the field, by that compensation field. So you can no longer do that. Hopefully closing the door on that particular concern. There is a second part to this particular point where the DOJ was also saying, hey, we also don't want people to be able to search by brokerage or by agent ID or broker or office ID, which was interesting. I mean, the rationale behind that is in our market, I'm sure in many markets, there are some discount brokerages who offer, their services for a lower fee, and thereby, by extension, offer perhaps a lower buyer's agent's compensation. And the DOJ was saying, look, we don't want people searching by those particular brokers or those particular entities to keep their buyers away from those. So it's the same concept as the compensation search, but this is specific to the listing brokerage. Well, I understand the rationale. We're not certain that this is the best idea. You have to understand that these issues and these decisions affect MLS staff and AOR staff as well. And we search by agents and broker ID a lot, right? We have to figure out what's going on with someone or check their history and their activity. What they're saying is we won't be able to do that either. And so that's sort of a very limiting, kind of the rule might be too broad for its own good. So we're hoping that when these rules come out for a period of public comment, or when the opportunity comes up for us to give input, that NAR will push back on this one a little bit. The third thing doesn't necessarily implicate MLS issues so much as it does code of ethics. Article 12 in your NAR code of ethics has for a long time allowed buyer's agents to advertise their services as free, right? Quote unquote free. And there are some ins and outs of that. Well, the DOJ has basically said that's not allowed anymore, right? You're not going to be able to do that. It's a debatable question, right, of whether or not the statement is actually true. I think we know that, at the closing, the seller's not bringing in any money. The buyer is basically bringing the check, or the buyer's lender is wiring the funds. and the proceeds are coming out of the buyer's money to pay their agent. So the DOJ is saying, look, this is a little bit of sleight of hand in our estimation, so we're not going to allow you guys to say those kind of things anymore. And the fourth issue that the DOJ settlement, NAR settlement addresses is lockbox use, lockbox access. Again, under the umbrella of consumer protection and the benefit of consumers, what the DOJ is saying is, look, buyers who want to find homes and want to work with, let's say, non-NAR affiliated agents shouldn't be precluded from viewing homes that are listed in the MLS. And the concept here is that only the other participants and users of the MLS can get the lockbox codes to go and see the house. So what the NAR is, or what the DOJ is saying is, your lockbox system, whatever it might be, has to now allow non-MLS agents and brokers to get access to these homes to show them. From our perspective here at CRMLS, it's not technically difficult at all. Most of the lockbox businesses and operators allow for one-time use codes. So if a non-MLS agent were to contact you as a listing broker and say, I really want to see this, give me access to the MLS so I can get the code, you don't have to do that. You can generate a one-time use code in your system, and then they can go and see that. So that's going to work itself out. I think there's been, a little bit more controversy over that than is necessary, but I do understand some of the concerns. We certainly understand some of the concerns that listing brokers might have, in that non-NAR, non-realtor, agents out there are not necessarily undergoing the same kind of oversight and or training, by virtue of being part of NAR, CAR, or a local association. Keep in mind that the seller is the one who actually decides ultimately who can see their home. Okay, and so it's the DOJ being concerned with listing brokers discriminating against non-MLS agents and brokers is somewhat maybe a little bit off the mark. I mean, it's really up to the sellers as to who they want to allow their home to be shown to. So that's the big lawsuit that is still, like I said, underway, and we'll be certainly sending out any information on any of these changes as the rules get closer to being finalized. The other point in the litigation world, I'll go over this and then I'll be done, is the particular lawsuit amongst many out there that was filed against NAR and us here at CRMLS and two other large MLSs in the country last year, filed by the private listing service. Okay, this is a Bay Area, Central California independent multiple listing service, non-NAR listing service. And the PLS was claiming and arguing in their federal lawsuit that they filed that the clear cooperation policy, right, the pocket listing policy that came out last year, was anti-competitive. Okay, they filed under the antitrust, federal and state level legal cause of action for antitrust, saying that the CCP, by forcing all MLS users to put their listings in the MLS, was somehow damaging to consumers. They argued that as they are the PLS, they wanted to keep the idea that you can take your listing and put it in their private MLS and not have to put it in the MLS that you're a member of was beneficial to consumers. Well, ultimately, the court said no. All right, so we had filed in response to this, and we and the other defendants had filed a motion to dismiss. Well, about a month ago, the motion to dismiss the case by PLS was granted. Remarkably, it was granted with prejudice, which means the court told PLS, your arguments are so flawed and your chances of prevailing on your arguments that you have are so slim that we don't think you can fix this. In litigation, you can amend your complaint from time to time to change things up to help your case survive. And in this case, the court says you can't even survive because your arguments are so implausible. Why did the court say that? Well, there's two prongs to an antitrust case. And it definitely has to be anti-competitive. It has to harm competition. But the two factors that make something anti-competitive are, number one, it harms a competitor, right? So a group of competitors in one market get together and make a decision and create and implement a business practice that harms someone else who's trying to compete in that market. Okay, that's prong one. The second prong is that decision not only has to harm the competitor, but it also has to harm consumers. Well, the first prong was a lot more plausible for the PLS, but it was the second prong that was a real problem for them. They simply could not articulate how the CCP, the Clear Cooperation Policy, actually harmed consumers. It wasn't a bad argument to say that it harmed them as a competitor, but frankly, that's just business, okay? You don't just get to use antitrust law to keep people from engaging in business practices that might be better or more savvy than yours and that you don't like. What the problem the court says was that the CCP, Clear Cooperation Policy, was actually pro-consumer. The PLS tried to say, well, we have all these sellers out there and buyers who need a private listing network, and the court says, we don't think so, okay? The Clear Cooperation Policy ultimately drives more listings into the MLS. And what that means is greater exposure for the seller's listings, which ultimately, by the laws of economics, would result in the highest price being paid for the property. And that the greater inventory in the MLS also provides for greater selection and greater opportunity for home buyers. These are the arguments that were made in favor of CCP from the impetus of the policy coming through the process at NAR. And the court basically agreed with that and says, we understand, PLS, that you don't like this, but the CCP is pro-consumer. And if someone doesn't want to put their listing in the MLS, as you argue so many people do, PLS, you have the office exemption. Okay, the inter-office exemption in the CCP says that if you want to keep your listing out of the MLS, but you want to market it within your office, your brokerage, you can do that. And the other option is if you're really someone who doesn't want your listing in the MLS, you can work with someone who's non-MLS affiliated, a non-NAR agent. So the options there and the underlying sort of benefits of the CCP, according to the court, were very pro-consumer, and so that case was dismissed. Now, it's not over. The PLS did file an appeal at the Ninth Circuit level. We don't have any knowledge of what their appeal is going to be based upon. Our suspicion is they don't like the fact that they weren't given the opportunity to amend their complaint. So the whole with prejudice idea in the court's order or the court's ruling is probably what they're going to challenge, but we'll know more in April. So good news for us and some of these other issues, and that the CCP has sort of survived this and been, reviewed by a federal court, and those findings are beneficial to all of us. There are other commission-related lawsuits ongoing in the country. In the Midwest, there are several class action suits, and then there was a case filed in federal court just this week by a San Diego area buyer against NAR, the Greater San Diego Association of Realtors, the San Francisco Association of Realtors, Compass, Realogy, KW, Sotheby's. It's basically the same genre, same approach that the Midwestern antitrust or class action lawsuits are saying, which is the idea of commissions and the practice of charging commissions and how commissions come about is causing people to have to pay too much for their homes. So from a seller's side, the argument is we know that commission is not set by law, right? It's always negotiable. But the arguments are, well, here's kind of, yes, that's true, but here's kind of what everybody always pays. And the seller side argument is, well, I'm having to pay too much to these buyer's agents because of what the common practice is. And then on the buyer side, they're saying, I'm having to pay too much for the house because the price is inflated to cover these commissions. So commissions are a little bit under assault, guys, in the courts around this country. So we'll be keeping an eye on this. We don't know how that would affect the MLS, but it's something for you guys to be aware of. I'll take a pause there. I'll be talking about some CRMLS specific rules, but I'll move on. I'll let everybody move on to John's John's presentation here, Ed.
Okay, great. Thank you very much, Jeff. John, you want to wrap it up? I think James is still muted, so hopefully he's able to reply to some of these questions that are coming in directly to that person so we don't clog up the chat. But while that's happening, John, go ahead.
All right, well, good morning, everybody. I'm just going to talk really briefly about a couple of hot topics that we're getting a lot of calls on, not only from Laura and her people, but also from the other associations that I represent. And so I want to just go over a couple things. First of all, something I know that Brian, we talked about at the last CAR meeting. You need to be careful about using forms that were not generated by the California Association of Realtors. Right now, we've had a number of new brokerages that are coming in to the business that have not been what I guess we would call traditional brokerages. One of them has their own forms. And here's the problem. First of all, if you're not familiar with a form and you're reading it over and then you're interpreting what this means for your client, you're conceivably practicing law without a license, and you might get a letter from one of Carlo's nice people. Because you're not supposed to practice law without a license. Your job is to go over forms, but not to interpret them for your clients. So Article 13 and various provisions of the Department of Real Estate and other state law does restrict you from even talking about contracts that were not prepared by your organization for which you were training. The only other exemption to that probably would be contracts or addendums or advisories that were prepared by your company and their lawyers, and then trained, given training for you. But again, there's traps. I looked at one set of forms that one of the CAR directors in Brian's region sent me. And when I looked at that form, I realized, my goodness gracious, for a realtor who's simply glancing at a form, who's not interpreting them, there were some real traps. First of all, there were some significant waivers of the contract rights that a buyer would have to get additional information. The seller property questionnaire, for example, which is not a state mandated contract or form, but is simply an advisory form that's produced by CAR to supplement the transfer disclosure statement, is being waived. Another area that I saw some real concern in was in the area of buyer's remedies. Right now, if a buyer believes that the seller is breaching the contract, well, they have a number of remedies available to them, including filing a lawsuit to tie up the property and recording a lis pendens. Those rights are waived. Now, whether a court would enforce that or not, you never want to get your client into a situation where they're being required to hire lawyers to interpret something you did or did not tell them to do. So again, be very, very careful about contracts, addendums, advisories that are not generated by the California Association of Realtors, because it's conceivable that you could be putting your client in some serious jeopardy. And frankly, you may be putting yourself in some jeopardy as well, because again, you have a fiduciary obligation to your clients to go over all material information, and certainly contracts you are not familiar with requires you to at least disclose that aspect. We've seen it before. It's not something brand new. Obviously, whenever you're representing a client in a new home construction, most of the time the new home developers are going to want to use their forms. And so this isn't anything new. Another issue, Ed, that we've been seeing a lot lately is because the market has been so hot. Now, whether that will change again, I'm really looking forward to hearing the economic forecast at the next meeting that Brian mentioned. But one of the things that we're seeing in order to sort of sweeten up the pie a little bit is buyers waiving contingencies. And while that may or may not be a good strategy for contract formation, it does point out some problems. First of all, what is a contingency? It is a condition precedent to the obligation to perform. So if Laura puts down a deposit on a house and has one of the 9 contingencies, that means that until she satisfies herself that that contingency can be removed, or she cancels the transaction under the contract that CAR created, she's generally entitled to get her deposit back. And so from that standpoint, there are protections for her and her deposit. But if you waive a contingency, and the one I'm seeing a lot lately, and I don't know, Brian, if you're seeing it too as a practicing realtor, and Ed, I know you do a lot of work with brokers yourself, is we're seeing a waiver of the appraisal contingency. The thought being that the property will appraise because, my goodness gracious, the market is exploding like gangbusters, and I've personally seen that myself. On the other hand, if you've overbid on a property, the appraiser may not agree with your strategy and may decide that, you know what, the property isn't worth what you're paying for it. That's a business decision you need to make. Well, if you don't have an appraisal contingency, that operates to allow the seller to retain that deposit, and you now have to make a decision. Can you come up with the additional money to meet the appraiser's obligation, opinion, all of the other things? Obviously, I'm always concerned whenever a realtor tells their client to go ahead and waive the inspection contingency, because now you're suddenly buying a home without all the protections of having the seller make those disclosures. So again, be careful, because if you've waived the contingency, then you've basically put the deposit on the buyer's side. And that leads again to another issue, Ed, that I'm seeing a lot, and that has to do with arguments over who gets the deposit. There's a case, I don't know, Ed, if you were at the CAR meeting, but we talked about a case where a realtor was representing a buyer. The buyer then found another property a day or two after they opened up, or they made an offer which was accepted by the seller. They went into escrow, and then a few days later, the buyer says, you know what, I'm going to change my mind. I found another property I like better. And the broker says to the buyer, hey, don't worry about it. We still have all these contingencies. You'll get your deposit back. Well, you have to be able to show, in order to get your deposit back, that you were removing these contingencies in good faith. You applied for the loan. You arranged for the inspector. You did things that again, Ed and I and Jeff understand, and James, of course, understand, that are good faith issues. Well, in that particular case, because the broker said, hey, my buyer changed their mind, we get the deposit back because there's the contingencies. The arbitrator disagreed. The arbitrator not only awarded a very substantial deposit to the seller, but also awarded all the attorney's fees that went along with that arbitration. And the award back to the seller was a judgment well in excess of $100,000. So be careful. And that leads me to my final point here, which is that, we all make pretty good living off of your mistakes, and you don't want to make us richer than we already are. So one of the things you don't want to do ever, is you never want to give an opinion, because it's a legal opinion. You're going past your license. You don't want to give an opinion, it's safe to cancel because you're getting the deposit back. There are always issues. I will tell you time and time again, people don't understand contingencies. They don't understand the way the contract is set up. Small claims judges even make mistakes because of their belief when they went to law school 30 years ago of what all this actually means. And now they've been doing criminal law, and suddenly they're sitting as a pro tem in small claims court. So never give an opinion that, hey, it's safe to cancel. That's really something that you need to be very cautious about. Also, don't give an opinion on who acted in good faith. That's a factual question that requires, as Carlo pointed out before, evidence, right? We follow evidence. And as a result, if there's not evidence of good faith, then it's conceivable that a court might not agree that you acted in good faith, because again, you're not qualified as realtors to measure what is and what is not good faith. And then be careful about who's entitled to the deposit. Most of the time, the deposit should go back to a buyer who has been acting in good faith, and because they can't negotiate a request for repair, or they can't get the loan because the appraisal contingency or something like that stands in the way, they're going to have a right to cancel. And most of the time, they should be able to get their deposit back. But I got a call on Monday from a broker that said, hey, I just got sued in small claims court because the buyer didn't get the deposit back, and she's the listing agent, and the buyer assumes she's holding the deposit, even though it had gone into escrow within 3 days after acceptance. So people just simply don't understand this. So don't give that opinion. As deposits go up and up and up, it's becoming more and more dangerous for you to render those opinions. I want to switch gears a second and remind all of you that NAR has changed the code of ethics, Article 10. And again, I will tell you that probably I've been practicing law for over 40 years. I know so has Ed. Jeff a little bit less time, and James maybe about the same time as the rest of us. But I can tell you that never in my career have I seen fair housing take the front burner the way it is right now. And that is at the regulatory stage. The state has 50 pages of new fair housing regulations that require you to act. The Department of Real Estate, if you engage in discriminatory practices, has a right, and will, Carlo can point out, and James better than I, but we've seen them take actions if there's a real estate related discrimination. You've got civil law, and the department and the National Association of Realtors has really put this on a front burner. They've hired people, created a diversity section. And so what they did recently is they said, look, we don't want realtors besmirching, belittling the entire industry by saying stupid things on Facebook and social media to each other that are hateful. And so they created a standard of practice 10.5. Standard of practice 10.5 says that you will not engage in hate speech, which includes epithets and slurs. So the first question is, would a reasonable person who is looking at what you wrote or said think that it was hateful, right? Not necessarily political comment, not a religious opinion, but hateful in and of itself. Number two, was it aimed at one of the 9 classifications under Article 10, race, ethnicity, sexual orientation, gender identification, etc., familial status, and of course, Americans with disability. So they're going to look at that. And if the answer to both those questions is yes, then you could end up being suspended from membership. You could end up being fined up to $15,000. You could end up being reported to the Department of Real Estate, again, if it was real estate related. And I want to, in terms of my personal observations of this going around the state that I do, you need to understand that in addition to those 9 categories, California has over 20 categories of protected classes. So while you may not get in trouble at the NAR level, the Department of Fair Housing can step in. And if you're doing something discriminatory as to those 22 categories, you're going to get yourself in a lot of hot water. And of course, Carlo may send you a letter, and James may file an accusation against you if it's really serious. And those are great guys. I've dealt with both of them many times. They're good men, but you always cringe a little bit when you hear from them, particularly James, because then it's the water's already under the bridge, so to speak. So be careful about what you say. Be careful about getting into arguments. I saw a case recently that's been filed. I can't go over the details because it's pending, but the thrust of it was, I now get into an argument with Brian, and he calls me a name or I call him a name. And as these arguments sometimes go, it ramps up. And suddenly, instead of calling Brian a bearded hypocrite or something, dumb and childish, frankly, I end up calling him something that's racist or relates to a gender issue or something like that. That's what I'm seeing. And I was privileged to do a panel a couple of weeks ago for the state bar we call it CEB, continuing education. And that's what we all agreed to was kind of where we're seeing it, where you get into, now there are people out there that are doing incredibly stupid things, no doubt, but really most people aren't going to be that blatant about it. So be careful about that. A couple of other things, again, talk to Lori Smith, who's your professional standards manager. Her most common calls still are people conducting open houses. I know that we're hopefully starting to come out of this house arrest, lockdown, whatever you guys want to call it. But the reality is the CDC rules are still in effect, and there's limitations on both housing, open housing and showings. The hottest topic, other than fair housing, still landlord-tenant rate, rent-related issues. And so again, if you have questions about that, I'll try to do my best. The governor has signed into law for you brokers out there, a new sick pay law that basically is retroactive to January 1st, requires you to offer 80 hours for all your employees. And then lastly, and this is actually a good thing, I don't know if it's going to go through when we get to the April 9th member meeting. Christine or Tim can comment on it, but it passed out of the Senate yesterday, and it's a bill that will double the amount of money that a handyman can do without a license. It goes up to $1,000. So if right now I believe it's $500 or $600, including materials, where you can use a handyman for fix-it-up items. You know, Brian wants to patch up some walls or, you know, fix a leak, but, you know, again, can do that for less than the current amount of the exemption. And there's a bill that's passed out of the Senate committee. It will now go to the Senate and then on over to the Assembly. And if it passes and the governor signs it, we'll create an exemption for up to 1,000. So film at 11 on that one. We'll continue. We'll let Laura know. She'll put it on the website, and you guys got to pay attention to the website. So I think I'm going to stop now, Ed, because I know you're going to get a bunch of questions. Frankly, I read some of the questions that you sent us. They were brilliant, and I'm really hoping that some of those questions get asked, because I've got a whole bunch of answers for a bunch of them, but I'll leave that up to you and the questions that the membership wants to talk about. So okay. I'll shut up. I'll do what my wife has been praying for a long time, which is I will hit my mute button.
Okay, well, not for very long, because we do have a question coming in. It's kind of a DRE question, so maybe we'll throw it over to Carlo, and of course, James is welcome to respond in the chat to the gentleman who asked it. The question is, I was involved in a fair housing complaint by a tenant, excuse me, regarding a property I was managing. Subsequently, I was contacted by the DRE and audited. Was the audit triggered by the complaint to Department of Fair Housing and Employment? So I guess the question is, does a complaint to one agency filter over to another agency? Are you guys working together, conspiring with each other? Carlo, why don't you start out, and we'll take it from there.
Well, we do work with agencies, but it's based on referrals. So for example, in this gentleman's question, if the Department of Fair Housing got a complaint and part of that issue falls within our jurisdiction, then they may refer it to us. Or the complainant sometimes files multiple complaints to several departments. So if we get a complaint on a property manager and the issue entails trust fund handling, then that triggers the department to want to audit. An audit sounds horrible, but it's how we're going to get to see the records, how the money came in, why did it go out, is there canceled checks? So it depends. Without knowing the specifics on that complaint, I can't say that the Department of Fair Housing forwarded to us or the complainant sent it to us. So it could be a mixed bag of, possibly several complaints going out to several different agencies. I hope that answers the question.
Thank you. John, do you want to jump in on this one, or maybe even Jeff? Jeff, I've got a question for you though after this one. So John, any thoughts on this?
I know I talked to Carlo when NAR was considering, and I've seen this before. I've talked to Brandon Butler over at DFEH, and my experience, in the trenches is exactly what Carlo just said, that sometimes one will trigger another, or maybe Carlo isn't sure that he has jurisdiction because the complaint has to do with discrimination, say, for example, which is what he and I talked about, but not necessarily related to something which they have jurisdiction over. So they could conceivably then turn it over to DFEH. And I'm sure Brandon would do the same thing if he sees something that would be serious enough and of interest to the department, turn it over to Carlo, or when I say Carlo, obviously his department, or one of the prosecutors like James. And so, yeah, I can see where that can happen very, very easily. And, you know, you got to always remember that the primary goal, and these guys take this thing very seriously. You know, we may not, you know, those of us that are more conservative may think sometimes that things are a little bit crazy, but the reality is their goal is to protect the consumer. That's the primary function of all these departments, is to protect the public. And so if they see something where there's another agency that might have an interest because the public's been harmed, not just because of what they do, but also maybe because of what another department does, they may refer it. And so, yeah, I can see that. I can see that very clearly.
Okay. Another question we have, and I'll start this with Jeff. It stems from this disclosure of commissions, and perhaps tongue in cheek, the question is, would the listing agent commission need to be displayed as well?
No, absolutely not.
Okay. Okay. So just the commission on the cooperating agent side.
And let's be clear. So the way the question is phrased, I want to make sure that we all understand. She asked, would the listing agent's commission will be displayed as well? We're not telling you what you have to display, right? Keep that in mind. All the DOJ is saying, and NAR is agreeing to, is that it's available. The BAC is now available in the MLS data feed, whereas before it wasn't. The decision as to whether or not you want to display the BAC at this point is still entirely yours. Okay, so keep that in mind.
So I list a property, and I really am concerned about if I put the commission in there that I'm offering to the cooperating agent, it's going to create some sort of rift between buyers asking discounts, maybe approaching me directly, wanting a discount if they write an offer directly through me. And I don't want to get into a procuring cost issue with another agent who actually showed them the property first. And I say, you know what? This just doesn't look good to me down the road. I am going to allow members of the MLS to see what I'm offering them through the MLS, but I do not want this to go out into the general public, almost like an SCLI where I'm, or an SCLM, I guess an SCLI, where I'm not going to be sharing this with the general public. That's
No, okay, so yeah, maybe I didn't phrase it articulately. The idea that who has the option to display it, it's not the listing broker, it's the person who has the website. All right. So if you are a listing broker and you put your listing in the MLS and you put in your compensation, that compensation is that field is going to be transmitted in our IDX feed, in our data feed payload.
that goes out to, say, realtor.com then.
Yeah, correct. Or, let's say, Laura's a broker and she has a great website and she gets an IDX feed from CRMLS and other MLSs to display property so that consumers can come and search. She is going to be the one who has the power to decide what fields are going to be displayed on her website. And that would include this new BAC being available for her. But as a listing broker, you're not going to be able to say, nope, sorry, right? So, because as the MLS, what the DOJ is telling us is, under no circumstances are you going to be able to make that confidential. Whether it's our decision here or the listing brokers, it's going in to the data feed payload.
Do we know what realtor.com is going to do? I assume Zillow is going to display it.
I don't know. Zillow's a broker and they get the same rights and responsibilities as the other brokers now. So it's their call.
Okay. Another follow-up question here, Jeff, to be clear, the non-MLS agent would still need to have access to Supra. So I guess we have a non-MLS agent, but they want to get into the property. We do it with the Bluetooth feed on our cell phone. They would need a cell phone. Do they need to be a Superman? How does that all going to work if they're from out of the area?
I'm not sure, because the idea is that we need to give them access. Okay. Whether or not the rule that comes out is going to include a requirement that we also provide a system that's easy or free or something along those lines, or if it's going to allow for a requirement, like, hey, this is the kind of lockbox we use, you need to join this particular membership or whatever it might be. I don't know yet. I mean, obviously, if you have a mechanical combo lockbox there and they text you, you can just give them the code. Whatever, if it's a super key and you do have access, the opportunity to create a one-time access code, is this rule going to say, if this person doesn't have Supra, you can't do that? Guys, I don't know yet, right? So I just know the concept, but I don't know how the mechanics are going to work on that regarding this particular hypothetical.
Okay. The next question, maybe we'll start off with John, and as he is answering the question, we can see if Carlo's going to be gritting his teeth on this one. What would be the legal and proper response to a buyer that would like the buyer's agent to show them a property that is only being offered at a $1, $2.50, 1%, etc., but an extremely low amount of compensation by the listing agent in the MLS? If a buyer's agent determines this is not a suitable offer of compensation, how would they relay that to the buyer, considering the buyers now will see that in the BOC?
That's a great question, Gina. And, I'm going to really be interested in Carlo's view, but from an ethical standpoint, number one, you need to set up your minimum. All of us charge we all work for money. Brian has a fee structure. I have a fee structure. When Jeff was out in private practice, he had a fee structure. We all have fee structure. I'm not willing to work for less than X number of dollars. So at the very beginning, you ought to be clearing that up. Personally, I wish they would make it mandatory. I wish Carlo would get the assembly to pass a legislation that said you have to have a buyer broker representation agreement where all that's spelled out, but we don't. We have the forms, you guys don't use them. So number one. Number two, never, ever, never negotiate your commission inside your offer. The National Association of Realtors, it is Article 16, Standard Practice 16.13 is very clear that is an ethical violation and an interference with another agent's listing to put it in the offer. What you need to do is I need to call Brian. Hey, Brian, I see you're only offering 1%. I have a buyer, but I'm not willing to work for 1%. Would you be willing to sign a cooperating broker compensation agreement separately that you will offer me whatever the amount is? And if Brian, now that puts both of you in a very interesting position, because both of you have fiduciary obligations to your clients. Brian has a fiduciary obligation to the seller, and you have fiduciary duty to the buyer. If you guys can't agree because you put your own interest before your clients, then you may need to back out because, and you may end up in some trouble down the road because there's some real ethical considerations there. Because if Brian says no, and I'm not willing to work for $1,500 or 1% or whatever it is, I'm going to have to pass the buyer on. And Brian, of course, if that offer doesn't come in, has just damaged his client as well. And I think there's some significant ethics issues separate from the contract issues on either side of that situation. And then Carlo, I don't know if you or James have any comments on the implications for the department, but certainly from an ethical standpoint, there are some, Gina raises some really, really heady, I mean, frankly, Laura and I and Lori have talked about doing a compensation class simply on the very, and Ed, I would invite you to participate in that, because I think this is protecting your commission and dealing with commissions and all these commission related issues is a class in and of itself. But from that standpoint, I think basically you start with, advising your own client under Article 1 of the Code of Ethics, what you're expecting as a compensation. Number 2, you talk to the other broker, you negotiate outside of the contract itself, and then you see where you're at, and it may very well be you're going to have to pass, or try and get a referral fee of some sort from the listing broker, who's trying to double end the transaction. Frankly, that's what he's doing, but that's a whole nother issue for another day. Carlo, what do you think?
This is a complicated situation because commissions, typically the Department of Real Estate does not have jurisdiction over commission disputes. But this is different because you got a buyer and their agent who may have seen a property that the listing is offering only 1% to the cooperating broker. So the issue for the Department of Real Estate is going to fall under failure to forward the offer. For example, we have a listing agent who's offering very little commission. We have a buyer's agent who may make the buyer's offer contingent on a certain set amount for a commission. Well, you got to compartmentalize that issue. The commission part, again, the Department of Real Estate lets the Board of Realtors and civil courts deal with that aspect. We want to make sure that the buyer's offer is communicated. So if a agent receives an offer for a property and fails to forward that to the seller because of their own personal reasons, they don't want to pay higher commission or they want to double end, that's going to subject that agent, the employing broker, and the corporation to license discipline because it's misrepresentation. You get an offer, you have a duty to communicate that to your seller. If the offer is contingent on a commission issue, well, that's different. But again, I always want licensees to be bulletproof. How are you going to be bulletproof? Try to be as transparent as you can. You have to think things through. The department's not going to care about, let's say, for example, earnest money disputes, John mentioned earlier. As a facilitator, I'm going to digress for a second, John. As a facilitator, we handle complaint resolution program type cases. These are licensees doing licensed acts, but the underlying issue is civil and contractual. Mm-hmm. So if you have a commission dispute, if you have an earnest money dispute, we get those complaints, and this program's been around since 2009. We try to facilitate a resolution. If we can work it out, it's confidential, it's voluntary, it's free, and if we can fix it and get the parties to work it out themselves, fantastic. If not, we don't investigate these issues. We let the Board of Realtors, the ethics, or civil courts handle it. So I don't want to get involved in commission issues, John, because again, that's something that the agents and the brokers figure it out. But if the agent failed to forward an offer or do a material act that impacts a buyer or seller because of their greed on commission, well, I'm sorry, that's going to subject them now to license discipline.
And that's also a violation of Article 1 of the Code of Ethics, which says you were to put your client's interest primary. So both in the hypothetical I use, both Brian and I would be violating Article 1 if I'm not honest with my buyer in terms of the reason that the offer is not being presented is because of my need for more money on the buyer side. And if Brian is negotiating a low commission simply because he wants to keep more of his commission for himself, I believe from an ethical standpoint, regardless of what the Department of Real Estate does, I believe from an ethical standpoint, we're both violating Article 1 of the Code of Ethics. And when you violate Article 1 and a panel comes forward and says you've done that, that exposes you to all kinds of civil and other issues that you really don't want to get involved in. So bottom line, put your client's interest primary and figure it out. It's not about you, it's about the client. So
I'd like to add one more thing, if I may, John.
Go.
Earlier you mentioned referrals and transfer disclosure statement forms. let's be clear that under Business Professions Code 10176.5, the transfer disclosure statement is a must. It would be a violation of the department's rules if a brokerage tries to do away with the TDS or try to come up with some sort of a waiver by the buyer on the TDS. That would subject that agent, the broker, because the broker at no point relinquishes their supervisory duty to license discipline if they try to somehow do away with the TDS. So if anyone's thinking out there that they're going to get crafty, well, you better think twice, because if we get a complaint on that, that agent's going to be subject to license discipline. The other issue is, and this, I've evolved on this issue and on referral schemes. And I just want to mention this briefly. The typical referral scenario that I always think about is the cocktail party, where let's say we're all at a cocktail party and I am just a regular Joe, not licensed. And I find out my neighbor John is selling his house. And at the cocktail party, I tell Brian, hey, Brian, by the way, John is selling his house. And so what happens then is, indulge me on this, I'll be brief. John ends up being the listing agent. Brian ends up being the listing agent for John, sells his house successfully, and comes to me and says, hey, Carlo, here's $500 for referring John to me. Well, if we freeze that moment, I didn't do this in expectation of compensation. I didn't wake up every day trying to do something where I'm going to earn commission or a referral scheme, referral fee. This was a cocktail party, one time event. That's okay. You could do that. But if I'm waking up every day and going knocking on my neighbor's doors and saying, hey, you selling your house? I got a great agent, Brian, he'll sell your house. Now I'm in violation of unlicensed activity 10137, because now I'm trying to get paid for doing, in this case, licensed acts. So you want to be careful on referrals. Now, the issue that we see in the real estate world is you'll have these title companies, escrow companies that will say, well, we're going to go to the XYZ real estate brokerage and do a presentation for their 1,000 agents and say, hey, most agents referring title to us will earn them a trip to Hawaii sometime down the line. That's a violation under 10177.4. That's inducement. That's inducing someone to do something to refer. You cannot do that. 6 ways till Sunday. You cannot give a gift card or buy them an item for referring business. You want to be very careful. I've seen the little, for example, there was this one lender that was willing to pay for all the advertisements for the real estate company so long as they referred all their buyers to that lender. So it gets complicated if there's some sort of a relationship there. For example, I could be a broker and own a title company. That's okay. I have to now have an agency disclosure to my clients, to all parties involved, that I own these companies. That's not what we're talking about. We're talking about separate entities trying to refer business and corner the market and take advantage of a certain city where they're cornering the market by sending business to one another with certain incentives. And it could be down the line. It could be a trip to Hawaii next year when I look at all the agents' stats and I see that, hey, Brian had most referrals to Carlos Title Company. So be careful on referral schemes. It might seem benign. It might seem, that, hey, I'm just establishing my name. Well, that's going to get you to lose your license.
I've got a case right now that I just got in where the escrow company simply gave a little thank you and a $5 or $10 gift card. I think it was Starbucks or someplace like that. And you guys are looking into it. So it isn't the big ticket even. It could be a small ticket done all the time,
Yes.
because the question really is, we call it in the law capping, where we get these people out there to go bring us in business. And that's against the state bar rules because it's unlicensed activity. Okay, and I'm sorry.
Okay, got some
But
more
it is real. It
questions.
does happen.
Okay, so Zillow requires buyers to use their forms. How do we address that? Now that Zillow is a brokerage, and if they are members of the MLS, shouldn't they be required to use CAR forms? So we've got two issues here. You can't very well require somebody to use forms, but at the same time, if you're not familiar with the form, then you cannot really represent your client effectively, because you would be giving or engaged in the unlicensed practice of law of trying to interpret that form. So, John, maybe you'd like to lead off with that, and maybe we get a little input from Carlo and Jeff. But yeah, that's a real problem. Sometimes we see with the larger brokerage companies, then they create their own disclosure, but of course, a disclosure is not a contract. So generally, signing a disclosure is not going to get you into trouble, but signing a contract, particularly a non-CAR contract that you're not familiar with, could create all kinds of problems. So John, why don't you lead off with that?
Well, that was the subject of my first part of my talk, is that's what we're seeing now. I know Laura and I have seen this question come up 1 or 1,000 times already, and here's a couple of things to remember. First of all, we are not talking about Zillow. We're not talking about any particular company. We're talking about the act of using another company's forms that you are unfamiliar with. I don't want to get into this. I am still Association Legal Counsel, and we are not talking about Zillow. But if we were, we would be reminding everybody that any company that becomes a brokerage and then joins the Realtor Association, any Realtor Association, and Jeff's MLS or any other MLS, is no different than all of the people watching this program right now. You are required to comply with the Code of Ethics. And of course, the Code of Ethics has many areas where it talks about presenting offers objectively and all of that. It has restrictions on practicing law without a license and all of that. And then, of course, Jeff has all kinds of rules that apply to everybody equally. And so, again, the fact that Zillow is requesting this doesn't mean that they don't have the same duty. Everybody talks about Zillow or any of these other big techie type companies. You're going to be seeing those. They're coming into the business. They're not going to go away. As technology continues to expand and your business, your industry becomes more and more technical in nature, these issues are not going to go away. New mousetraps are being developed all the time. But Code of Ethics over 100 years old. Department of Real Estate's been around for over 100 years. I've been around almost 100 years. Jeff has been, his rules are pretty stable. And so when I say, hey, I want to be a broker now, I no longer want to be a platform or whatever they've, gone from, they're now required to obey the rules. And if they say, we're not going to present offers unless you use our forms, it's going to be interesting. This is just starting to happen. So somebody's going to need to gather up the courage to file a complaint, and then we'll see where it goes. Jeff is in the same boat. Somebody files a citation violation or presses the button, we're going to see where it goes. And then, of course, there are potentially Department of Real Estate questions. There is an exception. I remember this happened, probably Ed, you do too, back when CAR came out with the new RPA, which was about 10 years ago. And agents are slow to learn sometimes, and they were using the old RPA. And realtors were saying, we will not accept a form that is not the current CAR form, right? You guys are getting a brand new RPA coming in December. It is really different. 16 pages, completely revised. I like the form, but it's going to be tough to teach it. You're going to have to learn. So if I get an offer in on the old form after December, then I'm going to have a right to say, no, I want you to write it on the current form, because that's the one the California Association will stand behind. So there are some nuances to this, but I think if Zillow's, I saw the form, and I listened very closely to what Carla just had to say, because when you read that form, that their addendum, it pretty clearly says, to the fullest extent of the law, you are waiving all the disclosures that you can possibly waive. People need to remember that does not include the TDS. It does not include the other statutorily mandated forms, lead-based paint if applicable, NHD, all those things. But there are other forms that are referenced in the purchase agreement, the CAR purchase agreement, that would be waived, the SPQ being one. And so be very, very careful about that. And then to answer the question, yeah, you're going to have to tell them, look, just like you would say if there was a surveying question or a geological question or something outside your wheelhouse, the duty is to say, I'm not qualified, I'm not a lawyer. Yeah, you need to maybe spend an hour with our company attorney or with your own attorney, however, you've set it up. And,
John, what about an alternative choice here? Say, look, this has come in on a form I'm not familiar with because I use CAR forms. I cannot advise you. You actually have two choices. You could either seek legal counsel. Yes, you'd have to pay for that. Or if you would instruct me, I can ask the other side to please submit on a CAR form and then give your client the authority, the responsibility to direct you to basically tell the other party, hey, put it on a CAR form, or this thing's not going anywhere because that's what my client wants. John, how do you feel about that?
I agree with that. I think that's a great point. I think the problem, of course, right now is that the iceberg that we're all sitting on is a seller's market, and as we shift over to a buyer's market, when Laura puts on the next program and we have an economic forecast, I think they're going to tell you that we may be seeing a slowdown, and I don't know if we'll see a seller's market anytime soon. But if we do, a buyer's market, then the bargaining position is going to change. But for right now, I'm selling a property, and I'm going to get a whole bunch of offers probably. And if the property is priced right, I don't need you. I can go to one of these others. The issue then is, how do you force Zillow or any other company that's using its own forms to comply with the ethical responsibilities of presenting the offer? And that's where I think we're waiting to see how both the department and, of course, our own ethics panels handle these things. It's going to be very interesting.
Okay,
it's a great question.
Carlo, Jeff, real quick, I've got some more questions backing up on the queue. Do you want to add anything real fast, or should we go to the next question?
Just real quick. Yes, you cannot waive statutory requirements. If an agent's new, and thank God we have people like Jeff, John, you, Ed, and the Board of Realtors to educate them. They can't say, hey, I didn't know. Too bad, so sad. Ignorance of the law is no defense. So don't try to get cute and waive statutory requirements. One more thing I wanted to mention is the crazy experience we've all gone through this past year, the COVID. The department's position on COVID cases, which I handled majority of them in Southern California, is not to be punitive. We want to educate the licensees when we get COVID complaints. And the COVID complaints entail property management issues where you have a tenant that is being bullied by a broker who wants to sell and is intimidating them. We get complaints on neighbors saying that the next door neighbors having a full-blown open house. And again, the department's position has been to educate these licensees who we've been complained on. The commissioner with the governor's office worked with the CDC. We have these guidelines on our website. I'll be more than happy to share with anyone who's interested. So, this whole experience with COVID has been so complicated. It's entangled everyone. But just to be clear, the department is not out to get licensees because they got sloppy and they didn't wear some sort of a glove or a mask. They should be wearing it. They could possibly, be negligent, but any issues that we've gotten, our first approach has been, let's educate the licensee. And I hope that resonates with the population out there. So don't be scared if you get a call from DRE about some COVID related issue.
Okay, so our next question has to deal with contingencies. As to removing the appraisal contingency, if a buyer removed an appraisal contingency but canceled after the home inspection due to the condition of the house, would the buyer get back the deposit 100%? And it goes on to say, I know John said that there is a risk that the seller might keep the deposit if we waive the appraisal contingency. So John, you might want to speak to essentially the three major contingencies: loan, appraisal, investigation / inspection. They're essentially independent of each other. We know that the loan contingency is now 21 days, but that may change in December to 17 days.
Yes, it does. That's right.
Purchase agreement. But maybe you could address the three contingencies and the importance of keeping them separate and distinct, even though they're all kind of lumped together in their removal in paragraph 14.
No, and I think the new form does a much better job of I know Brian agrees, but the new RPA does a much better job of separating out the contingencies and making it clear that each one is its own condition. And again, if you've acted in good faith, and that's why I said it's most likely that even though you don't have, say, an appraisal contingency, that if you've gone ahead and done a full-blown inspection and the inspection reveals problems that were not previously disclosed, and the seller will not take any steps to correct them, then yeah, you should, under most theories, get your deposit back. Same with, the lender fails to, provide the loan because something happened. Maybe the appraisal didn't come in where the lender wanted, or maybe you move jobs, or I saw one that was amazing. People were so excited about buying a new house, they went out and bought 2 new SUVs and lowered their credit rating significantly, and so the lender wouldn't lend. Brian's laughing, but they are independent. That's a great point, Ed. They are independent. But what happened in the case that you and I are aware of is that the realtor made a really dumb statement. Well, my seller or my buyer changed their mind. So right away the question became, well, then you didn't try to remove any of the contingencies. You didn't act in good faith. So really the advice is, look, these are complicated questions and you need to be very careful. But if the contingency is acting independent, so I've inspected the house, there's plumbing issues you didn't tell me about, there are termites, you're not willing to do anything, I'm not willing to buy a house that's in the condition that it is actually in, not the one that you represented, so I'm canceling. In that context, you should get your deposit back, but I've seen too many cases where the person did not.
And John, we probably should emphasize here that California law is pretty clear that in residential transactions 1 to 4 units, deposits are considered to be refundable. Now, if the liquidated damages clause is initial, that's something new, but one, agent should never write non-refundable deposit, because the only thing worse than the unlicensed practice of law is the unlicensed practice of the wrong law. But secondly, just because the deposit is refundable because the liquidated damages clause is not initialed, yes, you might get your deposit refunded, but the seller may sue you because it doesn't limit the seller's ability to sue for damages, right?
That's correct.
Yeah.
The liquidated damages simply means it's too difficult to determine damages. So we're going to agree that if you default, and so that's the key element, because if there's a contingency and you've acted in good faith and you haven't defaulted, but if you've removed the contingencies and then you cannot close, you've defaulted on the contract, which is to close an escrow at a certain price, then I get to keep your deposit up to 3% because we've agreed to these liquidated damages. One of the things we've agreed to, and Ed, I'm going to be calling you, you don't know it yet, but you do an excellent job of teaching the RPA. And so we've put together a little committee of myself, Linda DeStefano is your representative at Tri-County, is a phenomenal woman, and a couple of other brokers. And we're putting together the RPA class that will start offering sometime in the fall. Obviously, since you probably teach some of it, we want you to be involved, but we're going to emphasize liquidated damages because I think it's an area that people really don't understand. It's very complex and it is legal in nature. And so these realtors are out there saying things they shouldn't be saying. And, so it's a complicated area.
Okay, we've got 8 questions in the queue. Yes, Laura, I do see them, but my speakers are speaking, so I can't really interrupt them. Again, I try to be tenacious, but not rude. Okay, speaking of Linda, isn't the MLS offer of compensation to other realtors, wouldn't the non-MLS member be taking the risk of not getting paid a commission? So why don't we start with Jeff on this? And maybe Jeff, as you go through this question, you can address, we really got multiple categories. We have the unlicensed person, we have a licensed person who is not an MLS member or maybe a realtor, and we have a person who may be an MLS member but not a realtor. So you've got like 3 or 4 categories. So houses for sale, it's on the MLS, it's not in my MLS. I may or may not be a realtor, but let's say I'm a licensee. Jeff, how does all this pan out?
Yeah, the unilateral offer of compensation that you place in the MLS it's basically made to the other MLS participants and subscribers, as well as our data share partners. So the way it works for us is if someone's maybe not a CRMLS user, but they are, let's say, San Diego, that's a data share partner. So the compensation is made to them as well. Now, if they are a practitioner, a licensee, but non-MLS anywhere, I think the answer is yes, but let's be careful, right? Because the way that compensation is being viewed in today's legal environment is from an antitrust perspective, right? So the targeting of NAR and the affiliates of NAR involves the idea that there's sort of a minimum compensation. We know that's not true, right? We know that it's always negotiable, but the allegations being made is, yeah, but here's what really happens, right? So the DOJ is kind of looking askance at that and saying, we don't love that, right? So we want to be careful. And then the idea that non-MLS brokers and agents out there are sort of being pushed out, or there's an antitrust scenario that they can't do their job because the competitors, NAR, and all the people that are being alleged to be in business with NAR are making an agreement to keep them out, right? And somehow that harms them and consumers. Again, we're getting back to the core principles of antitrust. We want to be careful. They are definitely, it is factually true, but they cannot simply lay claim to it, right? Because they can only lay claim to it vis-a-vis being an MLS member. But are you able to just simply tell them, I simply am not going to pay you? That's where the question is going. The answer to that question has traditionally been, probably, right? But at this point, I can't tell you how long that question is going to be able to be answered in the negative because of these antitrust issues that are going on out there. Obviously, it's better for them to join the MLS, and if they're not, then they are going to have to negotiate with that listing broker directly. In terms of the non-licensee, I think we all here know that a non-licensee can't get a commission. So it doesn't really matter whether or not they're in the MLS or not. But it is that non-MLS licensee, what is their right to that compensation? As far as the MLS is concerned, the broker is making that offer only to the other MLS brokers and agents. What's going to happen in the future? It's something we need to be thinking about, right?
Okay, I've got a queue of 11 questions. I'm going to knock this first one out unless anybody objects. Buyer broker agreement up front would let the buyer know they may be responsible for paying part of buyer agent commission. Real briefly on the BRE, it states that the buyer could be obligated to pay a commission. However, if the agent is being compensated through the MLS, whatever they are being compensated at will offset what is in the buyer representation agreement. Your association has a recording of a class, pretty good class, I think, because I taught it, on the buyer representation agreement. It's about an 1.5 to 2 hour class. Contact Laura. She will show you on the website where it is. Watch that class. If you have any questions, send me an email. Next question from Laura. I have seen a lot of photos being removed by agents after close of escrow, which it leaves the agents with no photos to do comparables. I have seen a lot of photos that are being removed by agents. Okay, just a double thing. So I guess the question here is agents dropping photos from their listings once they close. Presumably they don't want other agents stealing their photos. I don't know. But it makes it difficult to do comps. Jeff, any comment on this? And then we'll join in with
Yeah.
Carlo and John if they have any. I don't know if there's a legal issue here or not, but go ahead, Jeff.
Initially, I would point out that it's not possible for them to remove photos from their listing after the listing goes into a finalized status. So after it closes or it cancels or it expires, the listing broker can no longer go in and modify that listing. So they're not going in and taking photos out post-closing. We won't allow it. Our system doesn't allow it. And frankly, California state law doesn't allow it. So
Maybe, Jeff, maybe they're dropping those photos the day before close?
it's possible. We don't have a rule that says you can't do that. I mean, I think it's not a good practice because you have, your colleagues and your peers out there, as this agent has, this requester has pointed out, they need that information. What we are seeing, so the reality is they can do that. We do have a rule that you have to have at least one compliant photo in under any status. So if they want to take out every photo other than the one exterior photo, we can't prevent them from doing that. I don't like it, and I don't think anybody else likes it, but we simply can't tell them no. The question that we're seeing a lot more, and I'll be brief on this, is the new owners coming to us and saying, we want these photos taken down, right? Because of privacy issues and concerns like that. Well, our position, our default position is guys, we can't do that. So Civil Code 1088 has been modified with CAR's help to require us to keep all our information in the listings for no less than 3 years. And that includes photos. So we just can't do it under the law. And then we get a lot of arguments like, well, it's privacy, rights of privacy. Well, the problem is you don't necessarily have rights concerning those photos because they weren't yours and they're still not yours, right? They belong to the listing broker. Now, I think,
Okay, I've got a ton of questions here, and Laura, correct me if I'm wrong. Do we have 15 minutes left? Laura?
Yeah, if you need to go a little longer, you can.
Okay. So go ahead, Jeff, but I just want to let me know, I've got 13 messages in the queue.
No problem. I'll wrap it up real quick. So that's the controversial issue right now. And guys, frankly, just so you know, we don't allow it. But John can maybe back me up on this. I believe that there's some talk about the new RPA, including some language that's directed at the buyers that says something along the lines of, hey, we recognize we can't go in and ask, photos be taken out. I mean, that's a loose paraphrase. I know we're sort of advocating it because we want the buyers to understand from the get-go, after you close, you can't do this, right? It's just not going to be allowed.
I think Sharon's comment, I'm looking at some of the questions in the chat and the buyers want their privacy. I know I just sold my home and the new people are in and of course there's, Jeff's got videos of the house and he's got, a drone flew through it and probably most of that stuff is still on. Well, that means that the bad guys can see, how the house is laid out and the new buyers really don't have any rights. And that's why, again, a buyer broker representation form, going to a prior topic, because you have to make sure that the buyers understand that, look, Jeff's got to keep this stuff on file. I think it's 3 years, right, Jeff? And so, yeah, they're not going to have privacy. And that's something that needs to be addressed because it's a fact, it's out there. And I get calls all the time from people, what Sharon's saying here, hey, the buyers now are complaining that, that the video that they saw that got them intrigued into coming and looking at the house is that same video that anybody can now see for 3 more years. And so you again, it's part of that whole issue of slowing things down a little bit and taking the time to go over not just the purchase price and you know, those kinds of terms, but the transaction. That's what you guys are. You're facilitators, and you need to do that. So because Jeff's not going to remove it. He can't by law.
Quick hypothetical, really. You think about what this would work how it would work if you could say that you have this right to these photos to control them. Well, can you then go back to the last 4 times that property was listed and have all those photos removed as well?
Right.
No, you can't. It's an absurdity. Neither can you go to that former homeowner's Facebook page or their Instagram and have them take down all the photos that they ever took of their kids' birthday parties in that house. Right. So, I mean, the implications here, I'm just not saying it, I'm saying it's not a simple solution. And we are under no legal compulsion to take them down. And again, we actually have the requirement. So it's just not as simple as the buyers want to say, you know, plant their flag of privacy and say, I get to say what goes. It's not how it works.
Okay, more questions coming in. This one probably for Carlo and John. So many escrow companies are giving buyers or seller discounts of escrow fees, then paying the TC transaction coordinator fee through escrow. It shows on the closing statement, and that's one way to get business from an agent. So I guess what escrow companies are doing is they are through the back door paying for the transaction coordinator. So I know that's something that's a concern to DRE. Carlo, do you want to take a first shot at it? Then we'll jump to John and then get on to the next question.
Sure. So there's nothing wrong with giving discounts to the buyer seller. That's upfront. My concern with transaction coordinators, and this goes back several years now, where you get these transaction coordinators that do a lot of work. Some of them are licensed, some aren't. And when the escrow closes, the seller gets spooked because there's a several $1,000 fee that goes to the transaction coordinator. Well, why am I paying my agent if I'm now going to have to also pay the transaction coordinator is their argument. And so to sort of anticipate that and prevent something from, you know, turning into a complaint, I would encourage licensees and brokerages to somehow be upfront with that I also have a transaction coordinator, that there's going to be fee. Personally, I think it should go out of the commission of the agent or the brokerage to pay, because the seller doesn't want to get some, you know, additional fees at the end of the close. But again, we don't get involved in commission disputes, but we will get involved if a unlicensed transaction coordinator is getting paid and there was no disclosure as to their dollar amount. So that's something that's a gray area. It's case by case, factual, it's fact-based. So I can't give you a blanket statement to cover all the nuances that come, tentacles that come out of a transaction coordinator scenario. But I would say to be bulletproof, be upfront, gauge your client, and see how this plays out. And to be safe, it's better off to just have it come out of your commission rather than have an additional fee subjected to the seller.
The only thing I would add, I agree completely with what Carlo just said. The only thing I would add is that from an ethical standpoint, it's probably a violation of Article 2 if in fact you're basically trying to conceal and or mislead your client. Article 2 says you will avoid those kinds of things. Article, I think it's 4 or 5, says you will disclose, you know, all the money and where it's going and any secondary money coming in. And then Article 12 says you're to be truthful in all your real estate advertising and all your real estate communications. So if you're basically playing a bait and switch game and you're caught, then Carlo's going to have a grand old time sending it over to James, who's going to have a piece of cake time making the case. And you're going to spend a lot of money on someone that looks like me, and you're going to end up being in trouble. There's a case out of Alabama where the federal government went after a company that was doing that kind of stuff. and they were calling it an administrative fee. And they ended up being hit for millions of dollars because at the federal level, they treble damages. So if they realize there's, oh my gosh, they've been doing this now for 7 years and there's $1 million worth of money that's been, taken from clients, they're going to treble that. And now all of a sudden, you're in some really big trouble. So don't do it. Be honest with your people.
Okay.
Yeah.
Real quick question coming in from Sharon. She's talking about the use of non-CAR forms and making comparison in the commercial world of the AIR contract. I think we would all agree that if you're in the commercial field, the AIR contract is very similar in terms of an industry standard as the CAR contracts are in residential. Second thing, be very careful not to confuse commercial and residential, because while the DRE will still get involved in a commercial, the level of care, because you're dealing with more sophisticated clients, does not seem to be quite as high with a residential client, particularly when you're dealing with a first-time home buyer. Richard's got a question. If the buyer removed all contingencies and found the seller misrepresented the square feet over 20%, can the buyer cancel, get the deposit back? And I will go further to say, be not likely to be sued for damages. So we have a misrepresentation of square footage by in excess of 20%. That was discovered during escrow after buyer has released all contingencies. John, your thoughts?
Well, that sounds like a really fun lawsuit. Again, as Carlo pointed out before, and as Jeff said many times, it's not quite that simple. I've supposedly done my due diligence. Why wasn't it picked up there? Was it an intentional misrepresentation, or was it a legitimate mutual mistake of fact, which of course is a defense to a legitimate contract? So there are a lot of issues. My attitude is, if the way that the question was written by the person, I would say, since it uses the word misrepresent, if I were the attorney in that case, I would be saying, look, you misrepresented. That means you lied. Since you lied about the square footage of the house, that means you had some knowledge, or you were negligent in the knowledge that you did have. Therefore, I would agree to cancel that transaction, because you're probably going to lose the lawsuit. But then again, there could be a lot of other factors. So, but the way it was written, it says that the buyer, or excuse me, the seller misrepresented. So in that context, yes, I think that you can still cancel and get your deposit back, but it may require that a lawyer intervene and do lawyer magic to kind of make it happen. And I think, frankly, if the realtor was involved in that misrepresentation, I'd like to hear Carlos' thoughts on that, because now you're talking about the consumer being tricked into buying a property that, and that, frankly, by the way, was the case of a major case that came down a couple of years ago called Herricky versus Caldwell Banker. It was a misrepresentation of square footage, and got the realtor. Now he ended up winning the case for other reasons, but it got the realtor into a whole bunch of hot water, which included 2 trials and an appeal all the way up to the California Supreme Court. I didn't want to know what that legal bill was, right? So, Carlo, any thoughts on that?
So the gentleman's question was the seller misrepresented. So obviously we have no jurisdiction over a principal involved. In rare instances, you'll have, of course, the complainant, let's say hypothetically with this gentleman's question, if the buyer files a complaint on the listing agent, because typically they'll do, their knee-jerk reaction is, I'm going to go after the listing agent. He or she lied to me about the square footage. Well, we get those cases. And again, we go where the evidence takes us. So if the agent has prior knowledge, and this is very difficult to prove on the standard of proof of clear and convincing, if we can show that the listing agent had prior knowledge, then yes, we'll file an accusation for misrepresentation, deceitful, dishonest acts, failure to disclose. But seldom you'll have a listing agent that has the prior knowledge element to prove that. And so it's the old, caveat emptor, buyer beware, do your due diligence, go, and there'll be instances where on MLS, I'll have some sort of a information that's not accurate, but MLS has a disclaimer that buyer needs to do their own due diligence. So again, there's going to be instances where you'll have a scenario where there may be an email by the listing agent making a statement of fact, which turns out to be inaccurate. That's going to be clear and convincing evidence of misconduct because they made a misstatement. But again, you have to make a distinction between the seller and the agent. In this scenario, the buyer wants their money back. They file a complaint with DRE saying listing agent misrepresented. We look into it. It turns out the seller did. So we close the case, and the buyer seller now have to go through mediation, arbitration, civil suit to get their earnest money back.
And the broker needs to be careful too, because 20% of what? I mean, if it's a 1,200 square foot house, that's one thing. But if you're talking about in the case that I'm thinking of, and it was a prudential case, I don't remember the name of the case off the top of my head. It's a very old case. But in that case, it was 20% of a 6,000 square foot house. Well, now what the experts testified to at that trial and what ended up getting the realtor in trouble, and again, it wasn't a DRE issue, it was a civil matter, is the fact that the experts said, well, shouldn't you have been, this was an experienced broker, shouldn't you have been able to see that this house was clearly not 6,000 square feet, that it was that it was 1,200 square feet less than what you were telling people? So there are factual arguments. And in the civil situation, it's a preponderance of the evidence, right? Carl's got to prove things by clear and convincing, which is a much higher standard. Only a lawyer would appreciate all these different standards, but you can trust us all, we're lawyers, right? It's a much higher standard than, say, preponderance of the evidence, which is more likely than not, right? So you open yourself up to some real problems if you're not careful. So I could see where a factual issue could be involved in that case. So be
Okay,
careful.
I've got a licensing question coming up, but two real quick ones. Laura, can you tell us whether this is being recorded or not? You're muted at the moment. Either a yes or no?
Okay.
No.
It is being recorded. Can I then jump in real quick? Again, Laura will put a disclaimer, but I'm telling everybody that's watching this program, if there's any plaintiffs' lawyers out there, we are giving advice at a much higher level than is necessarily the standard of care. And we are not giving legal advice. We are simply answering questions of a general nature without all the documents and facts in front of us. Go.
Okay. Real quick question. I think the DRE should be working harder. None of us really want a DRE visit, but just to everybody watching this, file your complaint with your association, file your complaint with the DRE, because if they don't know about it, they really can't do anything about it. But I have a licensing question I want to jump on real clear. There are unlicensed transaction coordinators and assistants doing work as transaction coordinators and assisting agents. So maybe Carlo, you can jump in here about what happens when we all have seen people out there masquerading as agents. I've seen people with cards saying that they're a real estate licensee, and they were not. They're not. So maybe you can address, Carlo, the dangers of a TC or an assistant in unlicensed or non-licensed status, and then we'll follow up with something from John. Carlo?
Yes. So the code that we enforce for unlicensed activity is Business Professions Code 10130. And it's really simple. If you're not licensed, you should not be coding rates, fees, discussing the sale aspect of the property. It's okay if you're unlicensed and you're assisting your agent or broker with, filing documents, possibly helping them on staging, other things, but engaging a client. And I see this on a number of levels. We're human beings, we have egos, and you want to sort of feel like you're contributing to it, but be careful, because the second you engage a client and he or she now is exclusively dealing with the transaction coordinator who is not licensed, and something goes wrong, you know, Murphy's Law always kicks in, something goes wrong, that consumer is going to file a complaint with the department against the agent's TC. And so what I would do as an investigator, I would get a declaration from that buyer. And this is a hypothetical I'm sort of digressing into. And the hypothetical essentially identifies the transaction coordinator as the face of that brokerage. The buyer or the seller never dealt with someone, or in this case, let's say the buyer never dealt with the agent, dealt with the transaction coordinator. So that declaration under penalty of perjury is telling me that the TC was involved and they never met the agent or the broker. Now it's going to hit the entire brokerage with unlicensed activity, which could subject them to license revocation. So be careful. Don't try to be that egoistic agent that's so busy you're going to have your TC handle it. Well, guess what? That might subject you to license discipline, get your broker involved. So be clear what the TC's role is. I always encourage brokers to have a policy and procedures manual that identifies the TC's role, filing, possibly sending certain follow-up emails that again does not touch on sales aspect. Fee structure, be careful. If the brokerage is paying them an hourly fee, fantastic. But if the agent's going to get greedy and say, I'm going to get my commission and I'm going to have the seller pay my unlicensed TC, that's not fantastic. That's going to subject them to license discipline.
And John, I know you want to jump in here, and I think you should, but could you also address the dangers of paying a TC or an unlicensed assistant as an independent contractor? Because the law clearly says if you've got an unlicensed person, they're going to be an employee. Go for it.
Again, you know, I'm a lawyer. That means I can't do anything quickly. But the bottom line is this. Look, first of all, Regulation 2725A makes it clear that the broker's responsibility is to make sure that the people that are doing licensed activity are properly licensed at the time. Also, under current law, if you do not have a license, then you are somebody's employee. And if you are an employee, then aside from all the employment laws that go into effect, then you are responsible for that employee's activity in a much broader way than you would be if they were an independent contractor. Independent contractor law and the way the DRE handles all that is different than strict employment law. So again, and it's fraud. Frankly, again, I keep coming back to this. If you're doing these kinds of things, if you're basically, to use Carlos' hypothetical, you know, I'm just so busy, I'm going to have, you know, and look at it from a legal standpoint. I'm so busy that I'm going to have my paralegal negotiate your contract for you. Well, you know what? You're not paying a paralegal to negotiate the contract. You're paying a lawyer to negotiate the contract and a paralegal to proofread it. And so there's a much different standard for that. Now, I'm not saying that, you know, some paralegals are smarter than a lot of lawyers I know, but the reality is that there's a reason for the license. So be careful, because you know, the law of independent contractors is under attack right now anyway. And certainly in California, we have AB 5, which is not you know, conducive necessarily to assuming someone's an independent contractor. And then, of course, under some federal legislation that's being proposed, that issue is being debated right now quite heavily. So be careful.
We have a real quick question that's going to take too long to answer, called, or saying, is there a definition of hateful?
I can answer that in 1 second.
Okay.
Webster's dictionary. They actually, if you look at the policy, I was on a panel last week with the guy that shared.
John.
Well, the first part was quick, but bottom line is they are using, NAR is actually using the definitions in Webster's Merriam Dictionary for hateful, slur, and epithet.
Perfect. Thank you. Two more questions, and I think then we're done. To be in compliance, agents who want to be paid through their corporations or other entities, as a broker or office, what should be required examples of articles of corporations, W-9? Is there a website to look at? So I guess we've got salespeople who have incorporated. The broker is concerned about compensating them John, Carlo, do you want to jump in there?
I'm
on
gonna let
the-
Carlo handle that one.
Okay.
So that's a good question, and I'll be more than happy to email anyone. An article was written years ago by DRE that touched on that issue. You have a sales agent that is also has their own corporation. They're under an employing broker, and the employing broker gets this escrow proceeds and now wants to pay the agent. The agent can have the broker pay the agent's corporation. That is not illegal. That's not a licensed activity. That's a issue that's internal between the employing broker and their agent. So for example, in a hypothetical, I'm the salesperson, John's my employing broker. I sell Brian's house. I could have, once the escrow pays John, who's my employing broker, who now is going to pay me, I could have John pay Carlo Benky's corporation. That's absolutely legal. There's nothing wrong with that. I've had many complaints where the broker doesn't want to do that. I can't get involved in the commission issue, but I could certainly put the broker's mind at ease that, hey, it's okay. And so, again, an agent can get paid through their broker to a corporation that they own.
Okay. Last
Take
question.
that article.
Okay. Yes, John.
I was just saying, I'll take the article, Carlo. That comes
I'll
up
email that
all
out.
the time.
Yeah. Last question. This is about the listing agent requiring buyers to be pre-approved by their lender. So they have it in the listing form or the MLS or confidential remarks. I want your buyer to be pre-approved by my lender with your offer. Then, of course, there's the corollary, which I think gets you into trouble. I demand that your buyer do their loan through my lender. So we've got really two issues. It's not really clear which way the question was going, but maybe we could address both of those. In a seller's market like right now, seller doesn't want to take their property off the market unless they've got a legitimate buyer, COVID notwithstanding, requiring pre-qualification by a lender that the listing agent believes in. The other corollary, or the follow-up question, what about requiring that buyer to go through their lender? John?
Well, again, I'm not going to speak for the department. I had a case not that long ago where, first of all, I don't believe it's a violation of any rules or law that I'm aware of that says you need to be pre-approved and I want you to use that lender. Where I saw the issue come up is I got a letter from, well, I didn't, my client got a letter from Carlo's nice people basically saying, we want proof that you weren't doing it for compensation. In other words, the broker, the lending broker better not be paying the listing agent any money for the listing agent's requirement that you be pre-approved. It's simply informational, particularly in a market like we have now, where there's so little inventory, to make sure that what you're bringing to your buyers to your sellers are legitimate. I do not believe it is appropriate or legal to require the use of the broker, the lending broker, but I'd really rather hear from the boss, because I've been told that it is not legal to say you must use the Brian Yates lending company for the loan, because that prevents me from shopping and getting my best deal. So, Carla, what do you think?
That's accurate. You cannot steer business. You cannot have some sort of a condition that you would have to use our exclusive lender. We see some of these on subdivisions with developers having a listing agent, and they try to steer the business to a set lender. But as far as the seller requiring the buyer to be pre-approved, hey, seller's the master of the offer.
Mhm.
The seller can require that. My advice to licensees in that scenario is to temper expectations, temper the buyer by assuring them that this is going to be confidential, that your information is not going to be disseminated to other third parties, that this is just a pre-qualification. Now, there's two ways. You could walk into a bank with a heartbeat and get a pre-qualification, or there's the more extensive one where they want to see seasoned funds, they want to see your credit score, and this is personal in nature. So then as a seller, I want to make sure I'm not getting some looky-loos that just want to look, but I'm getting a serious buyer. So that's a seller's, prerogative. But a listing agent cannot say you have to use my lender. That'll get them in trouble.
Right.
Yeah, and something else we should point out, both in the RLA CAA, that COVID addendum to the listing agreement, and I believe it's also referenced in, I call it the PAD, the PEAD, that you're supposed to have your buyers either pre-qualified or pre-approved before you start showing them properties, as well as show them the property virtually to try to limit the number of looky-loo buyers and possibly transmitting the virus. Last question that I have in front of me here. I know of a realtor using video to advertise his listing property. In the video, the realtor has his young children talk and give information on the property. Kind of reminds me of that, I think it's a Toyota dealership that has a little baby on the billboards that says, "Oh baby." Anyway, is this considered a violation? Because arguably that children who are clearly not licensed because they're under 18 are making representations about the property. Carlo, let's have you be the baby killer here.
That's a tough one. I mean, again, this is my opinion, not the opinion of the Department of Real Estate. Chances are that baby's not going to get paid. So there's going to be a violation of unlawful compensation. So really, we don't have a victim here. I don't like to touch that question. It's I don't want to be judged, but no, you don't want, you want to draw a line. You want to be cute and get your message across without violating real estate law. And you're just going to attract, a lot of haters, competitors who are going to file complaints. Before I finish, let me give my number out to everyone. Don't hesitate to call me. I always say this at any event, and my number's on the department's website. It's 213-576-6885. 213-576-6885. Don't hesitate to call me. Any real estate related questions. Of course, don't call me and expect for me to treat a fraudulent issue confidentially. No, I'm asking you to call me for any licensing questions you may have, or scenarios you're not sure of, or you may have some concerns about an agent or a brokerage you're working with. Please use me as a resource.
I don't see anything left in the queue.
I wanted to point
Laura?
something out, Ed, real quick. Sorry, it's Jeff. That last question about the video with kids in it. If that video is on the MLS, we're going to take it down. So just so you know, you cannot have children in any of your media on the MLS.
Really?
Good point.
Even if
Very
they're
good.
yours. It's just a safety rule. I don't think we're probably not going to issue a fine on that. But we have a rule that allows us to take down anything that we find improper. So that's just a policy that we have, so everybody knows. No kids in the media.
Okay.
I wanted to add one last thing, if I may, Ed.
Sure.
Jeff talked about, and I think it was John and Jeff, about the pictures, photos with listings. This is something that I've personally handled cases over the years, and you'll get a buyer that moves in with kids, and now the house that you purchased, there's 37 photos of the interior of that property on the broker's website. So they'll ask us to remove it because the broker is being unresponsive. Our approach is we contact the broker, we ask them to remove it. There's exterior pictures that's, in the age of internet, we can't control that. Zillow, Redfin, they all have it. Google Images has it. But interior photos that may be of private in nature. And in some instances, I've seen two, where there'll be some person under a witness protection plan. Believe it or not, I had a case like that, and some scenario where there was a battered wife of a domestic violence. And so we'll get involved on that, but we don't get involved with the MLS's own policy. That's their policy. But as far as interior pictures, if it's in the broker's control, we'd like to ask them to remove it if they can.
Yeah, and I'll finish up that thought because I forgot to tell you about this. There is a way after closing to have the photos not go out to the internet, but to remain in the MLS. And we have the option, you can, if you're the listing broker, you can just have the listing set to no internet. It's a simple switch that we can flip in here. If you're the listing broker, you can call in and we'll do that for you. Now that there's a consequence in that if you are tracking your stats somewhere out on a site, like how many sales did you close in 2020, that listing won't appear in there anymore. All right, so there's a cost to it, but you can definitely have it kept in the MLS, but not going out to the internet. And then the other thing is we are working with our tech team and with our platform developers to look into a private photo switch so that you could possibly designate certain photos as private. And so the rest of the listing content would go out to the internet, but those particular photos wouldn't. I don't have it ready yet. We have a lot of work to do. We have 3 different MLS platforms developers to deal with, but that's something we're doing and working on because we understand this is an issue that a lot of people want to have us address.
Anybody else? Comments, summations? I think my job here is about done.
Great job too, as always.
Yeah, that was a lot of great information.
Yeah.
And this is being recorded and it'll be found on our Tri-County's website in the next day or 2.
Super.
Just for clarification.
Brian, do you
I'd like to personally thank all, as association counsel, I want to thank the 3 of you and James for being so attentive, even though he wasn't able to participate. We'll get him back on some other time and get him all set up. But Carlo, you've always been generous to the associations, and want to personally thank you. And Ed, always do a great job. And Jeff, again, you're always very generous with your time as well. So on behalf of the association as general counsel and Brian, I just want to thank the 3 of you. And yeah, I agree with Laura. I got 3 pages of notes here. So it's a lot of stuff. So I appreciate it all.
Thank you for having me.
Yeah.
Thank
me
you,
too.
Thank you very
everyone.
much.
All righty.
Thanks for
Bye.
being here.